So, Bruno, when people are considering their estate planning and they're thinking of the future and they start thinking of structures, which one's better? Is it better to get a trust or an anti-nuptial contract?
So when getting married, the antenuptial contract is crucial. Remember, the thing with the antenuptial contract is if you don't enter into one, you're married in community of property. And all that means is that all your assets get thrown into one joint pool. So if you, as a husband or a wife, happen to get into financial difficulties or you have some debt that's outstanding, the creditors can come after both of you at the same time. So the antenuptial contract is crucial, irrespective of whether you're looking at doing a trust or investing or whatever the
So
case
it's
is.
two separate things.
It is two separate things, and the one is your baseline insofar as estate planning is concerned. So you should probably start off with getting the ANC. If you never invest, be it in properties or businesses, you're still okay. At least that underpins the protection moving forward. Past that, then you'd want to consider the trust. The reason for considering the trust is better estate planning. You're able to put your assets now into this trust. And remember, trust is a completely separate, is basically a separate person.
Yes.
And it would have these assets, would control these assets outside of your individual capacities, which means, for example, if you were to pass away, there's rules in the trust on how your kids would benefit from these assets.
Absolutely. So then on that topic, Bruno, if somebody's not getting married and they want to go build wealth, would you still advise they set up a trust?
Absolutely. A trust isn't, a trust doesn't, it's got no connection with whether you need to get married or not.
Correct.
The fundamentals of the trust is who is going to benefit from the income or the wealth the trust generates. So naturally, you're not allowed to create a trust where you're the only beneficiary. But if you have children, for example, parents that you take care of, organizations, charitable organizations, all of these things can be beneficiaries to trust. And the benefit of putting this wealth or this money or these funds into the trust is the fact that if you get into financial debt yourself in your personal capacity as a business owner, for example, or something happens, the trust is completely ring fenced and these assets are kept safe throughout.
Awesome. Thank you. So, Bruno, whether you're a property investor or you're just an average person and you're getting married and you're having kids, do I need to get a trust now? Why can't I just get a testamentary trust?
Sure. So a testamentary trust and an inter vivos trust, which is also known as a living trust, are two different vehicles. They're from the same family, as it were.
Yeah.
They achieve similar things, but from an estate planning perspective, they are positioned very differently.
Yeah.
The reason for this is a testamentary trust is only created once you pass away. It's a vehicle in order to make sure that your legacy past your death is well managed. So you'd see a lot of examples of this, for instance, where you would pass away and you'd have minors. So your children are very young. You want to put something in place to make sure that they get funded for university, for example. Now, you might not want to leave all the money at once and the money possibly gets utilized before they even reach university. So you'd create a testamentary trust, for example, to make sure that the money is applied for a certain period of time and not utilized. The capital is preserved, and only at the stage where they're about to go into university would it be released to pay for their fees. So it's a very specific vehicle that can have a very specific purpose. Now, a living trust can do the same thing. The difference is you don't have to wait. You don't have to wait to death in order for it to start applying. Now, why it's beneficial to start doing something like this now is if all the assets and your wealth is in your personal name and you pass away, depending on the amount that you have of assets that you have and the value, you might land up paying SARS quite a bit of tax on death.
Yeah.
And only at that point does everything get transferred and the testamentary trust created. The living trust, you can start with that planning right now, which means that you avoid the need to pay tax when you pass away because you start building the wealth into the trust immediately. You set the rules immediately. The trust subsists and you can still benefit from the trust. So there's no exclusion to say if you put it in the trust, only your kids can benefit.
Yeah.
You can continue benefit.
Yeah, absolutely. Thank you, Bruno. So, Bruno, I've got a company. Why is it important that I go get a trust as well? Or do I need to get a trust?
So it is two different vehicles and they serve two very different purposes. Now, maybe just for the sake of clarification, a company has shareholders. A shareholder has a right, a claim against the company, as it were. This means that if in your personal capacity you own shares and something were to happen and you're in financial risk and you get sued and somebody tries to collect debt from you, at that moment in time, your shares are exposed, which basically means that your business within the company is exposed because you can get removed from that business altogether. So that's one of the primary considerations is although running a business from a company protects you, so that means that the company can take risks, but you as a shareholder are protected. It doesn't work the other way around.
Yeah.
If you as a shareholder get exposed, your shares to the business are exposed. So what we do in these instances, in the realm of asset protection, is we insert a trust into the middle between you and your company. Now, this trust owns the shares. The trust in itself never really gets any exposure, doesn't have any debt, any liability. So the trust is purely safe. You are still a beneficiary of the trust. But the way our trust law in South Africa works is you don't have a vested right to anything in the trust if it's a discretionary trust, which means that no one can attach that and try get benefits from the trust. It's totally in the discretion of the trust whether you get any benefits or not. And that creates a buffer. That means that those shares can never be accessed. You can still benefit from the trust, but no one can attach the benefits in the trust that you would have.
Interesting. Thank you, Bruno.